What are conflicts of interest for California state legislators? Joint Rule 44 discusses these conflicts of interest. First, a member of the legislature may not, while serving in office, have any interest, financial or otherwise, directly or indirectly, and engage in any business or transaction or any type of professional activity or even incur any obligation that is in, quote, substantial conflict with the proper discharge of the member's duties in the public interest and of the member's responsibilities as prescribed by the laws of the state. Now, there are also conflict of interest provisions affecting legislators set forth in the California Constitution as well as in the California Government Code. These are the provisions of the joint rules of the Senate and Assembly. In addition, a member of the legislature may not, during their term of office, may accept other employment that the member has reason to believe will either impair his or her independence of judgment as to the member's official duties or require the member or induce the member to disclose confidential information acquired by the member in the course of and by reason of his or her official duties. A member cannot willfully and knowingly disclose for pecuniary gain to any other person confidential information acquired by the member in the course of and by reason of their official duties. A member cannot accept or agree to accept or be in partnership with any person who accepts or agrees to accept any employment, fee, or other thing of value in consideration of the member's appearance or agreeing to appear or taking any other action on behalf of another person regarding a licensing or regulatory matter before any state board or agency. Now, this joint rule 44 again, does not prohibit a member of the legislature who's an attorney at law from practicing before the Workers' Compensation Appeals Board or the Commissioner of Corporations and receiving compensation or from practicing for compensation before any state board or agency in connection with or in any manner related to a case, action, or proceeding filed and pending in any state or federal court. The rule also doesn't prohibit a member from making an inquiry for information on behalf of a constituent before a state board or agency if no fee or reward is given or promised for it. This prohibition that's contained in this rule does not apply to a partnership in which a member of the legislature is a member if the member of the legislature does not share directly or indirectly in the fee resulting from any transaction. In addition, a member is not to receive or agree to receive directly or indirectly any compensation, reward, or gift from any source except the state of California for any service, advice, assistance, or other matter related to the legislative process, except for fees for speeches or published works on legislative subjects, and accept the reimbursement of expenses for actual expenditures for travel and reasonable subsistence for which no payment or reimbursement is made by the state of California. Also, a member cannot participate by voting or any other action on the floor of either house or in a committee or elsewhere in the enactment or defeat of legislation in which the member has a personal interest, except one, if on the vote for final passage by that house to which the member belongs, of the legislation in which the member has a personal interest, the member first files a statement, which is to be entered verbatim in the daily journal of the respective house, stating in substance that the member has a personal interest in the legislation to be voted on, and that notwithstanding that interest, the member is able to cast a fair and objective vote on the legislation. then the member may cast a vote without violating any provision of this joint rule. The other exception is if the member believes that because of the member's personal interest, the member should abstain from participating in the vote on the legislation, then the member advises the presiding officer prior to the commencement of the vote, and he or she is excused from voting on that legislation without any entry in the daily journal of the fact of the member's personal interest. Now, a person subject to Joint Rule 44 has an interest that is in substantial conflict with the proper discharge of his or her duties in the public interest, or has a personal interest arising from any situation if that person has reason to believe or expect that the person will derive a direct monetary gain or suffer a direct monetary loss by reason of that person's official activity. Now, the person does not have an interest that is in substantial conflict with the proper discharge of his or her duties in the public interest. If any benefit or detriment accrues to that person as a member of a business, profession, occupation, or group to no greater extent than any other member of that business, profession, occupation, or group. In addition, a person who is subject to this rule may not be deemed to be engaged in any activity that's in substantial conflict with the proper discharge of that person's duties, if solely by reason of any of the following instances: that person's relationship to any potential beneficiary of any situation is one that is defined as a remote interest pursuant to the government code, or because of receipt of a campaign contribution that is regulated, received, reported, and accounted for pursuant to the Political Reform Act, so long as that contribution is not made on the understanding or agreement that the person's vote, opinion, judgment, or action will be influenced. Now, the legislature, in adopting Joint Rule 44, recognizes that members of the legislature, as well as legislative employees, may need to engage in employment, professional, or business activities other than legislative activities in order to maintain a continuity of professional or business activity, or that they may need to maintain investments, which activities or investments don't conflict with specific provisions of Joint Rule 44. However, in administering Joint Rule 44, weight should be given to any coincidence of income, employment, investment, or other profit from sources that may be identified with interests represented that are seeking action of any character on matters that are pending before the legislature. Now, an employee of either the Senate or the Assembly of the legislature may not, during the time that the employee is employed, can commit any act or engage in activity that's prohibited by Joint Rule 44. And any person may not induce or seek to induce any member of the legislature to violate this joint rule. And any violation of this rule is punishable pursuant to the California Government Code.